Okay, we're on the record in People versus Kenneth Kruger. This is file number 256832. The record should reflect that Mr. Kruger is present here in the courtroom today. This is the date set for sentencing in this matter. Mr. Kruger, did you have a chance to go through the pre-sentence report and talk to Mr. Trush about that?
Yeah.
Okay. And I know we've got a couple challenges to the scoring, Mr. Trush, but in terms of the body of the report, are there any additions, deletions, or corrections?
No, Your Honor.
And I did receive your challenges to OB 14 and OB 19. I had a chance to review that. Mr. Roll, I did get your responses. Mr. Trush, was there anything you wanted to say by way of oral argument first as OB 14?
So just very briefly, in regards to OB 14, I had an opportunity to review the prosecutor's response this morning. Responsive to that, I would just indicate, and I don't know if it's a typo, but he indicated in there that Mr. Kruger is in some sort of relationship with the owner of the vehicle. I don't think that there was any evidence either at the trial, in the police reports, or in the PSI that actually supports that. I can't tell you with honesty if there's a relationship there or not. There's never been any disclosed to me. The relationship was with the passenger. The passenger in the vehicle, Mr. Schneider, had a relationship with the owner of the vehicle, not Mr. Kruger. Outside of that correction or clarification, I would just indicate, I think that the basis put forth by both the department and the prosecutor for the scoring of OB 14 is really fundamentally exactly what the jury rejected in terms of what they came back with as their verdict, which is to say they clearly rejected the idea that he was trafficking and delivering drugs. I think that it's a small leap, if a leap at all, to say that they rejected the idea that he was the leader in that situation. I think it's clear that they accepted the idea that he had some knowledge, at least, that there were drugs in the vehicle. But I don't think that the way that they came back in terms of their verdict supports that he was the leader in a multi-offender situation. I think at best, it supports that they believed that both people in the vehicle were the owners of those drugs.
Mr. Roll.
Thank you. And for the record, my phone back to the people. It was a typo that actually should indicate that the defendant's passenger's girlfriend is the owner of the vehicle. In addition to that, as indicated both at trial and as also indicated in the PSI, this is also a circumstance where the passenger was doing this matter for Mr. Kruger in anticipation of getting some of the methamphetamine as a reward for setting up the use of the vehicle. So it's very, very clear that Mr. Kruger was at least one of the leaders of at least three people. By three people, of course, I'm indicating the defendant himself, his passenger, and the owner of the vehicle that the passenger arranged to use the vehicle for in this particular case. That is scored correctly. And again, to say that the jury's verdict makes this a decision for the court that scoring cannot be done either under OB 14 or OB 19, I think is inaccurate because, again, as the court's well aware, it's not a situation for the offense variable scoring that it has to be proven beyond a reasonable doubt. It's merely preponderance. Thank you, Your Honor.
All right, thank you. OB 14 is properly scored at 10 points when the court can find by a preponderance of the evidence that the defendant was a leader in a multiple offender situation. Again, the court has to apply a preponderance standard to its findings. The court can use information contained within police reports, pre-sentence reports. The court can use evidence obtained by testimony either from preliminary exam or from trial. In this case, we have trial testimony and exhibits that were admitted into evidence, as well as information contained within the PSI for the court to rely on. Number one, I think the court certainly can take into account the jury's findings, but I think Mr. Rowe is correct that the jury has to make their determination by beyond a reasonable doubt. The court only has to find for purposes of scoring an offense variable evidence by a preponderance standard. So there's plenty of room in between that for the court to make findings that the jury couldn't make because of the higher standard. And whether or not the jury, you know, felt that there wasn't sufficient evidence to meet the preponderance or the beyond a reasonable doubt standard, whether this was a compromise verdict, which we all know juries do from time to time. I think it's problematic for the court to read too much into the jury's verdict here in terms of scoring offense variables. Because of those reasons, we have no idea what the motivations of the jury were, what their findings were, what their deliberations were. We only know what their ultimate verdict was. So while I certainly take notice of the jury's verdict, again, I think it's problematic for the court to try and look too far behind that in terms of trying to divine what the jury thought or didn't think the evidence supported in this case. And so applying that preponderance standard, there are two pieces of evidence here that I think support scoring OV 14 at 10 points. Number one, that Mr. Kruger was operating that vehicle. To me, you know, the person who's in charge of driving a vehicle containing that amount of substances, the fact that they're in charge of that vehicle puts them in that leadership status, I think, compared to Mr. Schneider at least. And the fact that the defendant is the one who paid for the drugs or used his, you know, method of payment to obtain drugs, whether or not he ultimately was going to be repaid by somebody else or something, it's a different question. But those two factors to me show that the defendant was more than just a mere participant here, that he was a leader in this situation. So the court finds, and again, applying a preponderance standard, I think those factors make it more likely than not that he was more of a leader than Mr. Schneider was. So court finds OV 14 is properly scored at 10 points. As to OV 19, Mr. Truce, your argument.
Thank you, Your Honor. So this, I think, is a more nuanced argument. So I cited some case law that identifies a few different scenarios in which scoring is improper. And they're not scenarios that necessarily line up perfect with this. But I think the analysis would start with the idea that, let's assume for a minute that Mr. Kruger is not on probation. If he were to deny a search of the vehicle, does that support scoring under OV 19? And I think the answer to that is no. The answer to that is he would be within his legal rights to not consent to a search. So now I think we have to add the next layer of it is, okay, if it's not within his legal right to deny the search because he's on probation, and one of his probation conditions or supervision conditions requires him to consent to a search, does that now become interference with the administration of justice? And I think the answer is no, based on the case law that I cited to the court, because they identify several circumstances where a probation violation or even a violation of other court orders that are slightly different in context, but still court obligations, are not considered to rise to that level. So while I think that it may well be that he committed a probation violation by denying that search, and certainly the county supervising him and his agent could absolutely violate him for that. They may have, I don't know. I don't think that that rises to the level to score for interference with the administration of justice. So I think that's improperly scored. However, I think given the court's ruling on OV 14, even if the court grants this, I don't think it changes the scoring.
Thank you, Mr. Rowland.
Yeah, thank you, Judge. The case cited by the defense in support of their argument for OV 19, in addition to being unpublished, which is not binding upon this court, is dealing with two factual matters, which I think would distinguish it, even were it a published opinion. They're talking about circumstances of failing to pay child support and or failing to register under the Sex Offender Registration Act, which, as this court's well aware, there's a whole bunch of case law now that the persons can't even be charged under failing to register under the Sex Offender Registration Act unless the offenses occurred at post the amendments to the SORA statutes. So this is not about a circumstance of not paying money, just like with restitution. This is not about a situation of SORA violations. This is a situation where this defendant was under orders as a condition of probation, and it's not a suggestion, it's a condition of probation for which the court can impose sanctions, including sending him back to prison, that he chose knowingly, further indication, of course, that he knew the drugs were under the hood, to deny a search of his vehicle that he was required to consent to as a condition of probation. But as Mr. Trush has already said, in light of the court's ruling on OB 14, it's not going to change the guidelines scoring either way once the 10 points has been, as this court's rule, properly assigned to OB 14. Thank you, Judge.
Great, thank you. Again, I had a chance to review the briefs of the parties and OB 19. I did review the cases that Mr. Trush cited, and number one, I agree with the proposition that had there been no condition of probation here, OB 19 could not be scored. I don't think OB 19 can be scored for when a person's exercising their constitutional rights, which Mr. Kruger would have had. So I agree 100% with you on that point, Mr. Trush. I would also agree with you, Mr. Trush, if OB 19 here, the scoring was based on the mere failure to comply with a probation condition. I think that takes it into the child support case and the SORA case type scenario. I think what distinguishes this from that is OB 19 here, in my view, is being scored because of the effect or the intent behind his failure to comply with that condition of probation, which was to attempt to prevent police from finding the drugs in this case. And there was a recent Court of Appeals decision that's published. It's so recent it doesn't have a citation, but People versus Golder, and that involved scoring of OB 19. And that case held that conduct that constitutes an attempt to avoid being caught and held accountable can be scored under OB 19. And so in this case, I find it's not the mere fact that he violated his probation that results in the failure to, or the attempt to interfere with the administration of justice. It's the failure to allow a search when Mr. Kruger was required to allow a search for the purpose of preventing police from finding those drugs. And it's that difference again that I think distinguishes this from finding or attempting to score OB 19 just for failure to pay according to a child support order or failing to register under SORA. It's not the mere fact, again, that he didn't comply with his probation. It's that he didn't comply with his probation and refused to allow a search when he was required to do for the purpose of preventing the police from finding the drugs in an attempt to avoid being caught and held accountable. And I find that there's certainly a preponderance of the evidence, given the amount of drugs, given that he was a driver in the car, even he paid for it. He knew those substances were there. He knew that if the police searched the vehicle, they would be found. And he attempted to prevent that by refusing to allow a search when he didn't have any legal justification for refusing. So for those reasons, the court finds that OB 19 is properly scored. Mr. Trush, did you have any additional challenges?
No, Your Honor.
Okay. Mr. Rolla, did the people have any additions, deletions, or corrections?
No, Your Honor. Thank you.
Did people have any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Briefly, Judge, this is a situation, I'm not going to comment on the trial court sat in on that, and we have the jury's verdict, but this is a circumstance where we have 54 grams of methamphetamine, more or less, located under the hood of the vehicle being driven, operated, and controlled by the defendant. This is a situation where it's his second felony, second methamphetamine matter, third controlled substance matter, and he got the benefit of a 10-year gap, so an earlier offense was not scored. This is a situation where, quite frankly, the guidelines probably do not adequately address all of Mr. Kruger's actions, but we are here on this matter in any case. I think the court should take that into consideration. Thank you.
Thank you, Mr. Trush.
Your Honor, I think as we look at this case, it's somewhat unique, and I think possession with intent to deliver cases are always among the most difficult cases that we have. And they're difficult cases because we don't have the delivery, right? We don't have the figurative smoking gun, and we're often left to look inside someone's head to try to figure out what their intentions were. And I think they're difficult cases for trials. I think they're difficult cases for a jury to handle. When we look at Mr. Kruger's case, his criminal history is significant, but not the most significant the court's seen, and probably not the most significant the court will see today. He presents here with 1 prior felony and 2 prior misdemeanors. If the court looks at his prior history, I think a picture is clearly painted. As I see it, every one of his prior convictions involves substances. I don't think there's any doubt that Mr. Kruger is an addict and he struggles with substances. The guidelines here are 0 to 17 months. The court, under its discretion, could double them if it chose to, but the guidelines on their face are relatively low. Frankly, a level that would support a presumption against jailing. I don't think that's necessarily the right answer. Mr. Kruger needs help, and frankly, he needs to address his substance abuse issue. I mean, for himself, because frankly, again, this is now going to be his 2nd felony. I believe if I had his prior history right, his 2nd high severity felony. Guidelines are going to go up significantly. Court knows that. When we deal with these types of charges and methamphetamine in general, there's not a lot of chances, right? I mean, the guidelines get very steep very quickly. Mr. Kruger has another matter that is pending in Emmett County right now. He has indicated to me that his belief is he's going to be accepted into Emmett County sobriety court. I would suggest to the court here, given the circumstances here, given his background, and given the opportunity he has there, that my suggestion to the court would be a lengthier county jail sentence with an opportunity for him to complete that drug court program should he get into it, I think is the right response here. Obviously, again, it's not completely clear if he's going to get in or not, and that's why I identify that to the court, the opportunity to complete it if he gets in. Because frankly, I mean, we know if the court ordered him to sit a year in the county jail or 17 months in MDOC, I think we know from history the chances that he gets out with his problem addressed are pretty small. My opinion is the best tool that I think we have at our disposal right now to help people with substance abuse problems are sobriety courts. Their track record for success is simply the best tool that we have. So I would ask the court, I think that the circumstances here warrant a county jail sanction, not MDOC. I would ask the court to consider crafting that in such a way that if he can do a sobriety court in Emmett County would allow him to participate in that program. Thank you.
Thank you, Mr. Kruger. Anything that you wanted to say today?
The last few years, I definitely let drugs and addiction mess my life up, and I just want to get back on track, and I'm seeking treatment in the recovery court in Emmett County. I find out this month, the 21st, if I get in. They're voting on it, and they said that I'm a favorable person for it. That's not how they worded it, but a candidate for it. And so I want to get into that and get on with my life and put this behind me. Just ready to move on, live a normal life. Thank you, Your Honor.
All right. Well, I'm obviously familiar with what happened in this case. I presided over the trial. I heard all the testimony as you did. And I also got more information about you and your background and circumstances from the pre-sentence report. So I'm fully advised and I think all the relevant facts here. And it certainly is concerning the amount of methamphetamine that you were bringing up north. This vehicle was clearly involved in numerous buys. That's how the police got involved in the first place and started tracking it. And so it seems to me that there's a ring of individuals that you are connected with that were involved in regularly bringing amounts of methamphetamine up north to sell in the community. I'm sure to support your own habit, but you're also making it available for other people to continue with their habits. And to me, that is a degree of behavior over and above just being an addict and using and not being able to control your own use, which is one thing, but then bringing large amounts up for other people to be harmed by is an added layer of conduct that I think warrants additional punishment, and for you, but also as a deterrent, so that people understand that if you're going to use, that's one thing. If you're going to bring 50 some grams up north to sell to other people, that's something else, and it's going to be dealt with in a different way. The guidelines here are 0 to 17. Given your past history, I don't think that a prison sentence, despite the seriousness of your conduct, is warranted, given the guidelines and given all the circumstances. However, I do think a lengthy jail sentence is appropriate for the reasons that I've stated. So the court is going to sentence you to 12 months in the Otsego County Jail. You do have credit for 45 days served. Court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. In terms of any treatment courts in Emmett County, I'm always open to the possibility of somebody participating in a treatment court, but that is far from something that I'm even in a position to consider at this point. You haven't been accepted into it. I have no idea what the status of your charges are. I have people all the time come in front of me and say, hey, I'm about to be accepted into this. I have no idea whether that's true or not. So that's a sentence of this court. To the extent that you are eligible for a treatment court, and this sentence is the only thing preventing you from being accepted into that or participating in that. Documentation establishing that, then I would consider it. I'm not saying I would allow it, but I would certainly consider it. But again, that's not something that is going to be part of this sentence in this case, because it's just outside of my jurisdiction at this point. You do have the ability to appeal this sentence, and Mr. Trush, if you can have Mr. acknowledge receipt of his appellate rates.
He's already acknowledged and we've returned him.
Okay. Is there anything further that or is he going to go right back to Emmett County? Do they need a jail sheet?
That would be great. Yes, sir.
That's all for this file. Good luck to you going forward.
Yeah.
Ma'am, can you tell me your name, please?
That's Ms. Moses.
Ms. Moses. Ms. Moses, can you hear me?
Yes, sir.
On the record in People versus Ashley Moses, this is file number 256918.
The record should reflect Ms. Moses present today by video from Mackinac County Executive Council picture appearance.
Thank you, Your Honor. Richard Trush on behalf of Ms. Moses.
All right, Mr. Trush, can you tell me the status of this file today?
Your Honor, I guess I will put it to Ms. Moses. From my discussions with her earlier this week, I think we will be docketing this for a trial. There is an offer that would be a plea to count 1 and count 2 without enhancement. When I discussed that with her earlier this week, she had indicated that was not acceptable to her. So again, I obviously I want her to be able to weigh in on that, but my understanding based on that is that we will be proceeding with the trial.
Ms. Moses, were you able to hear that?
Yes, Your Honor.
How did you want to proceed today?
I would like to go through a trial.
All right. Mr. Rolla, how many days of trial do you think it would be?
We have 9 witnesses, Judge. I think it's gonna be actually 10 with the lab personnel. I think we'll probably use a day and a half. We might be able to get it in 1 day, but I can't guarantee that.
I'll set it for 2 days, Mr. Church. Do you believe that would be enough time?
I think 2 is probably the right number. I apologize. I was a little surprised by it. I didn't realize quite how many witnesses the prosecutor had on it. I think 2 days is likely sufficient. My guess is ultimately that we will wind up stipulating to the lab on this. I don't know that at this point, but it seems to me that's not where the fight's going to be.
Okay. And Mr. Rolla, do the people need any certain period of time to be ready to go to trial in this case?
Judge, just because it involves a lab person, obviously I don't want anything scheduled within 30 days because they're not going to be available. I'm not going to kid the court. You're well aware of that scenario situation, but other than that, it's more attributable to the court's calendar as it is the prosecution's.
Okay, so if we set it out 60 to 90 days,
I think that would be sufficient. Thank you, Judge.
Mr. Truce.
I would just indicate I don't need a specific time frame to be prepared for the trial. I would indicate to the court, Ms. Moses expects to be sentenced at, I think, the 14th of this month, where she's anticipating an MDOC sanction. So 60 day, obviously from our perspective, because she's lodged, we want the trial, we want to do it as quickly as we can. I think 60 days is probably safe because we have to worry about the quarantine time. So I would suggest, I think 60 days is an appropriate time frame.
Okay. And then we'll set this for a final status conference. Prior to that, that'll be the plea cutoff and motion cutoff to the extent that either side has any motions. Mr. Roller, are there any other dates I can address for your side today?
Not that I'm aware of. Thank you, Judge.
Mr. Truce.
No, I did just want to address, I mean, I know we addressed the underlying case, but I think was actually scheduled for a bench warrant arraignment.
That's correct, Judge.
I've got the paperwork right here.
Oh, okay. Right, and was Ms. Moses lodged somewhere at the time of her failure to appear for this hearing?
I don't believe so, but quite frankly, again, the anticipation is she's going into MDOC. Again, what she indicated to me was likely a 23-month sentence in about a week's time. I would just suggest to the court, to the extent that there is a bond in this file, we would ask to cancel it.
Okay. Any objection to that, Mr. Rowland?
No, Judge.
All right, so the court will cancel the bond. I'm going to recall the bench warrant based on the fact that Ms. Moses is now in custody. I'm not going to proceed further in terms of a separate hearing or sanction on the failure to appear, but I certainly will, take that into account as a part of overall sentencing if Ms. Moses is eventually found guilty. Okay, and Mr. Truce, if you could just prepare, in order reflecting that bond is being canceled. Ms. Moses, do you have any questions about how we're gonna proceed with your case?
No, Your Honor.
You'll be provided notice of the final status conference, which we'll probably do by Zoom as we're doing today. And then Mr. Rolla, of course, would be prepare a writ for her appearance at the trial dates once we get that.
And we would ask the defense counsel to please keep our office apprised of where she's at so we can have the writ done accordingly.
Sure. So Ms. Moses, there'll be a writ for your actual trial dates. You'll be transported here to Otsego County. Mr. Truce will work with you to help you have appropriate clothing for that trial while you're in court, and you'll get notice of the dates and times where you're lodged. Okay.
Okay, thank you.
Okay.
Ms. Moses, 2 things. When you get to MDOC, I will probably, the first communication you'll get from me will be a JPay email. I want you to understand those are not confidential. Do not discuss any of the facts of your case in those emails. You also will have to add me. I can set up video visits. So once you have the opportunity, you'll have to add me to your visitors list and then we can get those scheduled.
Okay, thank you. That's all for today. The court's going to disconnect from this time. Mr. Love, are you able to hear me okay?
Yes, I can.
All right, we're on the record in People versus Larry Love, file number 256902 and 6903. Excuse me, the record should reflect Mr. Love's appearing today by video by prior approval of the court. This is set for scheduling conference in both of these matters here today. Mr. Trish, can you tell me the status of the files?
Yes, Your Honor. We've been working diligently to resolve these as well as a matter over in Crawford County. I think Your Honor sits on all three cases. So it's probably no surprise to you. We asked to have this hearing set so we could engage and accept the plea agreement here. The plea agreement contemplates a possession of methamphetamine charge in each file as a habitual second offender notice. In each file, the remainder of the complaints would be dismissed. And we're looking for and asking the court to consider, I think, May 6th as the sentencing date, because that would allow us to line up sentencing here to happen the day before his sentencing in Crawford. So we can make sure that obviously we can get everything done.
Okay, so I just want to be clear. So in file number 256903, Mr. Love's going to plead to count one without the second or subsequent, but as a habitual second.
Correct.
And then in file number 6902, an added count two of possession as a habitual second.
Correct.
That's also correct, Your Honor.
Okay. Mr. Love, were you able to hear all of that?
Yes, I have.
And is that the plea agreement that you've discussed with your attorney?
Yes.
Is that how you wanted to proceed today?
Yes, sir.
You raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Love, are you currently on any kind of probation or parole?
No, I'm not.
And Mr. Trush, did either of these offenses occur while he was on bond for either of these files or the Crawford file, such that we have potential consecutive sentencing?
I don't believe so.
Okay.
I believe the Crawford file, I think, is first in line, but it was charged after the Otsego file.
Okay. So, Mr. Love, you're going to be pleading under this plea agreement to 2 counts of possession of methamphetamine as a habitual second offender. That means that each of those counts is punishable by a maximum of up to 15 years in jail or prison. Do you understand the maximum possible penalty?
I do.
With that in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during the trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. Do you understand all those rights?
I do.
And you understand that you're going to be giving up and waiving all of those rights by pleading guilty.
I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
I do.
Has anyone threatened you with anything to get you to plead guilty?
No,
Has anyone promised you anything other than what we've said here on the record today?
no,
Is it your own free choice to enter these pleas?
yes,
Are you pleading guilty to each of these charges because you are actually guilty?
yes,
So looking first at file number 6902, the information indicates that that happened on or about August 10th of 2025. Is that the correct time frame?
yes,
At that time, were you present here in Otsego County?
yes,
While you were here in Otsego County, did you have possession of some methamphetamine?
yes,
Did you know that that's what that substance was?
yes,
Did you have any legal right to have any amount of it at that time?
no,
The second file, 6903, the information indicates that that happened on or about June 25th of 2025. Is that the correct time frame?
yes,
At that time, were you also here in Otsego County?
yes,
And did you have possession of some methamphetamine at that time as well?
yes,
And did you know that it was methamphetamine?
I did.
Did you have any legal right at that time to possess any amount of that?
No,
Had you previously been convicted of resisting or obstructing a police officer as a felony in July of 2021?
yes,
Mr. Rolla, are you satisfied with the factual basis as to each charge?
Yes, Your Honor, I believe the court's set as a factual basis as to each charge. Courts comply with the court rule and the people who have no threats or promises not placed on the record. Thank you.
Mr. Trush, as to the factual basis,
I think the court has a proper factual basis.
are you aware of any threats, promises, or inducements?
I am not.
And are you satisfied that the court has complied with statute and court rule in taking this plea?
I am.
Mr. Love, the court finds that your plea in each case is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to each. We'll set this matter for sentencing. Or put it on the docket for May 6th. That makes sense to me to have it set at that time for the reasons stated by Mr. Trush. In the meantime, Mr. Love, somebody from the probation department will be in touch with you for a pre-sentence report. And it's important that you follow up with that contact when you get that, okay?
Yep.
Do you have any questions about how we're going to proceed?
I do not.
Mr. Rolla, anything further we need to address today?
All right.
Mr. Trush.
No, Your Honor.
All right, thank you, Mr. Love. That's all for today, and you're free to disconnect at this time.
Thank you.
We have people versus David Slating. I think he's been approved to appear by Zoom. Is that correct?
That's correct. We also have Mr. Ebler. He contacted me this morning and indicated he could not get a ride over from Alpena. I told him if he can't get a ride to log into Zoom, but I also informed him the court may not admit him or permit him in that manner. So.
Okay, so that's people versus Albert, file number 266962. Both counsel are present. Mr. Albert is not, for the reasons stated by Mr. Trush. And yeah, it's the policy of the court. If a hearing is scheduled in person, that Zoom appearances need to be by prior approval. I don't know whether what Mr. Albert's stating is true or not, but again, based on the court's policy, I don't allow individuals to just decide on the morning of, for whatever reason, that they don't want to appear in person. So the court will note that Mr. Albers failed to appear today. We'll set this for a show cause again, for the court's policy, if Mr. Albert fails to appear at the next hearing, then the court will issue a bench warrant for his arrest. All right, sir, are you David Slating?
Yes, I am, Your Honor.
Okay, thank you. We'll go on the record in People versus Slating, file number 26596955. The record should reflect Mr. Slating is before the court here today by Zoom by prior approval. If I could have counsel put your appearances on.
Record Chatter, Mike Rowland, behalf of the people.
Thank you, Your Honor. Richard Trush, being on behalf of Mr. Slayton.
Okay, Mr. Trush, how did we want to proceed in this file today?
So, Your Honor, I do want to give the court a little bit of background in terms of how we proceed forward and what we're going to ask the court to do here. So the court may recall at the last hearing, Mr. Slating was not here. He had sent information to myself and the court. I think basically the day before the hearing that he had been hospitalized. He remained in the hospital for I think about 21 days, had some fairly significant health issues going on. He's still in the recovery process from that. So when I spoke to Mr. Slating and at the last hearing, we had a plea agreement that we intended to accept. Today, I believe we're going to accept that agreement, and I'm going to ask the court to consider setting the sentencing out about 60 days. As a result of the medical issues that he's had, he's got physical therapy for the next 60 days. He's not permitted to drive in that time period. And frankly, without getting too much into the medical issues he's got going on, I think he would be at incredibly high risk for infection in that time period. So the hope is that if we get 60 days out, he'll be in a position where if jail is required of him, he'd be able to do that safely. That would be our primary concern.
All right. What are the terms of the agreement?
So he would be playing to count one, as well as, and I don't know if it would be an amended count 2 or an added count 2, but it would be an OWI second.
Actually, it's an added count 3, OWI second, and charge code 257.6256 D as in Baker. That's a 1 year, $200, $1,000 misdemeanor. And in return for the defendant's plea, count 2, the OWIL third would be dismissed.
All right, Mr. Slating, were you able to hear the terms of the plea agreement?
Yes, I can, sir.
And is that the agreement that you have discussed with your attorney, Mr. Trush?
No, it was basically what he was saying earlier, that it was going to be a second on the OWI, and then I think I don't know what he was going to do with the other item on that felony list. But I had heard previously that it was going to be reduced down to those, you know. It's just been my health. I would have been done and over with you guys. I got into programming early, you know, to show that, you know, I'm trying to be responsible and do the right thing. I've just had the worst luck run right now. So
I understand that part. I just want to make sure that you're clear on what the plea agreement is and that you've had a chance to discuss that with Mr. Trush. So the plea agreement is that you're going to plead guilty to count 1, which is the possession of the metallic knuckles, and that you're going to be pleading guilty to an operating while intoxicated second offense. Is that your understanding of the plea agreement?
yes.
Okay.
If Mr.
And that's
Truth gets as well, I like I said, I have a problem recalling things. So, yeah, Mr. Trush is, if that's what we discussed previously, then I'm willing to accept that.
Okay.
If
All
Mr.
right.
Trush, once again, if that's what we were, you know, talking about previously.
Mr. Trush, can you confirm that?
I mean, I do. I mean, Mr. Slagan, I do want to make clear that is the deal that we had discussed. And obviously we discussed what a potential sentencing in regards to that will likely look like, in my opinion. But I do want to be clear. I have some concerns with what you're saying, that you're kind of telling me that you want to do what I want to do. And it's got to be your choice if you want to make this plea.
All right, Mr. Truce, you just went out. I lost you.
So that is the agreement that we discussed, and
Okay.
we discussed what a likely sentence would look like as a result of that. But I do want to make sure some of the things that you said are giving me a little bit of concern, that you're kind of deferring to me. And like we talked about before, it's got to be your choice if you accept any kind of deal, right? I'm not the one who faces the consequences from it.
Right.
You would be to accept that. So is that what you want to do today?
Yes, I would.
Okay. All right, Mr. Slading, can you raise your right hand for me, please?
Yes, Your Honor.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do, Your Honor.
Thank you. You can lower your hand. And Mr. Slading, are you currently on any kind of probation or parole?
No, sir.
All right. And you understand that count one, which is the possession of those metallic knuckles, that's a felony that carries with it a maximum possible penalty of up to 5 years and or a $2,500 fine, and that you would have to forfeit or give up those metallic knuckles. Do you understand that?
Yes, I do, except for the time or the years. That would place it as a felony or as a firearm, wouldn't it? Or I guess
No, that's not a firearm. That's just possessing an illegal weapon that you weren't allowed to possess at that time.
okay. Mr. Trush, I don't know if we talked about that exactly, but
So
okay. But yeah, I guess let's move forward. But I mean, the 5 years max, I mean, that's taking me off guard a little bit here. But
Well, and you have to understand that that's not necessarily what your sentence is going to be. That's the statutory maximum possible penalty for that offense.
right. Yeah.
Do you understand that difference between what your sentence might be and what the statutory maximum is?
Yes, sir.
Okay. And similarly, with regard to the operating while intoxicated second offense, that's a misdemeanor, but it carries with it a maximum possible penalty of up to 1 year in jail and or a $1,000 fine. Do you understand that maximum possible penalty?
Yes, sir. Your Honor, I do.
Okay. With all of those things in mind, what is your plea to each of those charges today?
Guilty.
So right now you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all of those rights?
Yes, Your Honor, I do.
And can you tell me what's going to happen to those rights by you pleading guilty?
I waive those rights, I believe.
That's correct. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you have any questions about that?
No, sir.
Okay. Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've discussed here on the record today?
No, Your Honor.
Is it your own free choice to enter into this plea?
Yes, Your Honor.
Are you pleading guilty because you are actually guilty?
Yeah, yes.
Okay. So
Yes,
the
Your Honor.
date, the date that I have for this occurrence was back on October 17th of 2025. Does that sound like the correct date?
Yes, it does, Your Honor.
At that time, were you here in Otsego County?
Yes, I was, Your Honor.
On that date, had you been consuming some alcohol?
After that date, no alcohol or drugs. And
On that date, though?
yes, I consumed alcohol, sir.
Okay, and after you consumed alcohol, did you operate a vehicle on South Otsego Avenue here in Gaylord?
That's correct, Your Honor.
Did you have any blood or breath tests to determine the level of alcohol in your system at that time?
Yes, I had blood work done, and I also did the breathalyzer, of course. So, but I did both. And if you ask me to recall that number, I don't have that memorized, but I know it was up over the impaired. So,
It was above a 0.08.
something like that, I believe. And then they gave me a breathalyzer again when I got to the police station, and it dropped down to normal, but that didn't really matter at that point. But
Okay.
it was slowly dropping, but
Sure. Had you consumed enough alcohol that you believe that it impaired or prevented your ability to operate that vehicle in a normal and reasonable manner?
yes, Your Honor.
And at that time, did you have possession of some metallic knuckles?
Yes, I did, Your Honor.
Okay. Did you have any kind of license or other authorization to carry that weapon at that time?
No, I did not. We can see down here, we can purchase them anywhere. It doesn't make it right. It doesn't make it right, and I understand that, but they're on every street corner, every gas station. So I'm just not with it, I guess.
Okay. Mr. Rolla, are you satisfied with the factual basis as to both charges?
Judge, just one thing, I think the parties would stipulate that the results of the testing was a 0.135.
Yes, Your Honor, we would stipulate.
Okay.
And with that, the people are satisfied, of course, sufficient side factual basis as to accept defendants, please as to both counts.
Mr. Trush?
I think there is a valid factual basis. The court has complied with court rule, and I'm aware of no threats, promises, or inducements.
All right, Mr. Rolla, as to those other two matters?
People would agree.
Okay. So, Mr. Slating, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. In terms of the plea being knowing, voluntary, and accurate, I know you've had some medical issues. I've been listening very carefully to your answers today. It doesn't appear to me that your medical issues have impaired your ability to understand what's going on and to make informed decisions about what you're doing today. I just want to make a record that I've been paying attention to Mr. Slating's answers and just his general demeanor and behavior in court. And that I do believe that he has been able to understand everything that's happening here today. So the court is going to accept the pleas here. Mr. Rolla, do you have any objection to the sentencing being set out?
No, Judge.
Further. Okay, so we'll set this for sentencing in June. Any further delays beyond that, Mr. Trush, would need to be supported by medical documentation before the court would grant an adjournment of that June date. Mr. Rolla, anything further that we need to address today?
Never, thank you.
Mr. Trush.
No, Your Honor, thank you.
All right, so Mr. Slating, we're going to set this hearing for sentencing in early June. You're going to be mailed a notice of the date and time of that hearing. It's important that you stay in touch with your attorney between now and then so that you're prepared to go forward with that. Also, somebody from the probation department is going to be in touch with you, and it's important that you follow up with that contact, and that's part of the order of the court, okay?
Yes, sir. I've been in touch with her every week.
Well, this is going to be something different. I think you've been in touch with our community corrections person
Yeah,
regarding your
correct. Yes.
This is gonna be a different person from the
Oh.
probation department that's gonna
Okay.
contact you.
Okay, sir.
All right, thank you. That's all for today. Mr. Slading, you're free to disconnect at this time.
Thank you, Your Honor. Thank you, Mr. Trush.
Okay. Are you ready on Mr. Demick's case?
Yes, Your Honor.
All right, Mr. Demick, if you can unmute, please, we'll go on the record in People versus Eugene Demick, file number 256920. The record should reflect Mr. Demick's present today by video by prior approval of the court. If I could have counsel put your appearances on in this file, please.
Thank you, Your Honor. Richard Trish, appearing on behalf of Mr. Demick.
And Mr. Trush, how do you want to proceed in this file today?
Your Honor, I've had quite a few conversations with Mr. Demick between the last hearing and this one. Again, we were sort of keenly aware I came into the case late and that we probably weren't going to be given a lot of time in terms of, before the court would expect answers from us. I want to update the court on a few things. Mr. Demick did get screened for the Veterans Treatment Court down in Oakland County where he lives. He has been accepted into that program. We do have an offer from the prosecutor, which would contemplate a plea to counts 1 and 2 with a reduction from the OWI 3rd to OWI 2nd if he successfully completed the Veterans Treatment Court. I've discussed all of those things with Mr. Demick. It is his decision that he would like to proceed to a trial.
All right, Mr. Demick, were you able to hear all of that?
Yes, Your Honor.
Okay, I want to make sure that you're very clear on something because of the amount of time that this case has taken, that the court is not going to accept a plea to any lesser charges after today. So today is kind of your last chance if you want to enter into that plea agreement. So if you decide next week or in a month or the day before the trial that you want to accept the plea agreement, I'm not going to allow that. Do you understand that?
Yes, Your Honor.
Okay. And so is it your final decision that you wish to proceed to trial on this matter?
Yes, Your Honor.
Okay. All right. Mr. Rolla, how many days of trial do you believe you would need?
Looks like in this particular case, Judge, we have 1, 2, 3, 4, 5, 6. I think we could probably do it in one day.
Mr. Trush.
I anticipate defense will likely call 2 witnesses. I tend to agree with the prosecutor. I suspect 1 day would be sufficient. Even though that's kind of a high number of witnesses for 1 day, I tend to think that many of them are going to be short.
Okay. So I'll set this for a 1-day jury trial. Mr. Rolla, if we were to set this 90 days out, is that enough time for you to be ready?
That's fine, Judge. Most of the witnesses are the police officers.
Mr. Trush.
I think that would be fine. I would just indicate to the court, there's no specific time period that we need to get ready. The witnesses we're going to subpoena are civilian witnesses, but I don't anticipate any difficulties. I believe they would both be friendly witnesses.
Okay. All right, so we will set this matter for a one-day jury trial at about 90 days out. Mr. Demick, you'll get notice of the date and time of that trial from the court. Your notice is going to indicate that you need to be here in the courtroom ready to go by 8:30 on the morning of trial. It's also important that you stay in touch with Mr. Trush so that you can help him be prepared to proceed with your trial on that date. To the extent that either counsel has any motions, they would need to be filed and notice for hearing no later than 14 days prior to the trial date. And then I'll just ask counsel to follow the pretrial order instructions regarding submission of jury instructions and so forth. The court is not going to schedule any further hearings in this case. It's not going to accept any pleas after today. So the next date will be the morning of trial. Mr. Rolla, any other dates I can address for your side here today?
No, Your Honor, thank you.
Mr. Trush.
No, Your Honor, thank you.
Mr. Demick, do you have any questions at all about how we're going to proceed with your case?
Not at this time, Your Honor.
Okay. All right. Thank you. That's all for this hearing today, and you're free to disconnect.
Thank you.
We have Mr. Spencer present. Mr. Spencer, come forward. File number 266965, People versus Spencer. If I could have counsel put your appearances on that.
Your Honor, Richard Trush on behalf of Mr. Spencer. Your Honor, this is our first circuit court hearing. I've had some discussions with the prosecutor. We have an offer. I have it scored out slightly different than the prosecutor, and we're kind of trying to figure out where the differences are. So when we enter into it, we're confident about what a likely sentence is going to look like. The difference is it's enough that I think it changes the risk a little bit. The prosecutor sent his scoring numbers over to me this morning. Admittedly, again, I think I got them about 8 a.m., but I was already headed over here to the jail. Did not have an opportunity to go through it with Mr. Spencer. So I'm thinking if we had another 30 days, I suspect that we'll be able to get that done.
Okay, Mr. Rolla.
That's correct, Judge. This plea offered to counts 1 and 4 as a habitual. Second, it's a situation where I did, after request of defense counsel, score the defendant out and sent what I believe to be the scoring to him. It did go out this morning, and we have no objection to the 30-day term.
Okay. Mr. Spencer, have you been able to talk to Mr. Trush about adjourning this out? And do you agree with that? Yes. Okay. So we'll set this for a hearing in about 30 days. Mr. Spencer, it's important that you stay in touch with Mr. Trush and that you are ready with a decision at that next hearing as to whether you want to accept any of the offers or whether you would like to proceed with trial. Okay. Do you have any questions about that? Thank you. That's all for today. Mr. Clayton, were you ready with Mr. Shaw? Versus Shaw, file number 256927 and 256928. If I could have both counsel put your opinions.
Record, Your Honor, I love that.
Brian Smith, on behalf of Antoine Shaw, he's up for the right for purposes of jury status conference pre-motion cutoff date. I advise the court that we have a plea agreement in this case, in which to avail ourselves of. It is a reduced plea, but it is before the pre-motion cutoff date, so we should be able to proceed.
Okay, can you tell me the terms of the plea?
I can. So in file number 256928 FH, Mr. Shaw intended to plead guilty to take these into count 2. Count 1 and count 3 be dismissed by an entry acceptance of that plea. And count 256927 FH, Mr. Shaw is going to plead guilty to count 1, possession with intent. Count 2 would be dismissed by an entry acceptance of that plea. There is no sentence agreement. I tell the court that I believe that that's complete, a fair, and accurate rendition of the plea agreement in this case. I'm not aware of any promises, threats, or inducements that I haven't put on this record to incite the plea.
Okay, thank you. Mr. Rolla, is that a correct statement of the offer?
It's a correct statement, Your Honor.
Okay. Mr. Shaw, have you had an opportunity to speak with Mr. Clayton about this agreement?
Yes, sure.
And Did you hear what he stated in terms of the charges that you're gonna plead guilty to and which ones will be dismissed?
Yes, Your Honor.
Is that the agreement that you have discussed with him in the past?
Yes, Your Honor.
Did you want to proceed with that today?
Yes, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Mr. Shaw, are you currently on any kind of probation or parole?
I'm on like a probationary period, but I'm like really not. It was a school dispute with my daughter. And
Well, I think,
Well, I guess I'll answer, but
sure,
he does have, it sounds like maybe a deferred sentence for disturbing the peace. This would not affect that in any way because of the timing of the charges here, the timing of that. So he is on a probation or deferral, but this would not affect that. There's a misdemeanor, but it wouldn't affect it.
okay,
And I'm confident that, and speaking to Mr. Shaw, this could have no effect. It could not.
okay. All right, so, Mr. Shaw, you're gonna be pleading guilty to one count of possession with intent to deliver cocaine. That is a felony that carries with it a maximum possible penalty of up to 20 years and or a $25,000 fine. You understand that?
yes,
And then you're also going to be pleading guilty to one count of delivery of cocaine. That is also a felony that carries with it a maximum of up to 20 years and or a $25,000 fine. You understand that? as well?
yes, sir. Yes, sir.
With those maximum possible penalties in mind, what is your plea to each of those charges today?
Plead guilty to.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, sir.
Can you tell me what will happen to those rights by you pleading guilty? That's correct. Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. That means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you have any questions about that? Has anyone threatened you with anything to get you to plead guilty?
No,
Has anyone promised you anything other than what we've said here in court today? Is it your own free choice to enter the plea in this case?
yes, sir.
Are you pleading guilty to each of these charges because you are actually guilty?
Yes, sir.
So looking at file number 6927, the information, it says that that happened on October 7th of 2025. Is that the right time frame?
Yes,
At that time, were you here in Otsego County?
yes, sir.
Did you have some cocaine at that time?
Yes, sir.
And was it your intent to either give or sell that to another person?
Yes, sir.
Do you have any legal right to do that?
No, sir.
And looking at file number 6928, that was either on that same date or perhaps a little bit earlier, mid-September. Is that the correct time frame?
September 16th, I think. The date. Does that sound right?
Yes, sir.
Okay. And were you also here in Otsego County at that time?
Yes, sir.
Did you have possession of some cocaine at that time?
Yes, sir.
And did you give or sell that to someone else?
Yes, sir.
Did you have any legal right to do that?
I do, Your Honor.
Mr. Clayton, are you satisfied with the factual basis?
Yes, and I would simply indicate that we have received laboratory analysis on both cases indicating that substance actually was cocaine as well. I think that's necessary for the factual basis, that actually is. So, but I am satisfied, bending the jurisdiction being sound, the court has an adequate factual basis. I believe the court supplies MCR 6.3.
Thank you. Mr. Rolla, would you agree with the factual basis?
Yes, sure.
And Mr. Rolla, would you agree that the court has complied with statute court rule?
I would.
And Mr. Clayton, I believe you already covered this, but Mr. Rolla, are you aware of any threats, promises, or inducements other than what's been posted on the record. And you did.
I did.
Mr. Shaw, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea. Before you leave today, you're going to meet with Ms. Davis to set up a time for a pre-sentence interview. It's important that you follow up with that, and it's the order of the court that you do follow up with that. Also, it's important that you stay in touch with Mr. Clayton prior to the sentencing hearing. You'll be notified of the date and time of that hearing in the same way that you were notified of today's time and date. It's important that you stay in touch with him so that you're prepared to go forward at that time, okay?
And I'll just say, there's been no issue. Mr. Shaw has been great communicating with me in my office.
Okay, thank you for today.
All right.
You did, thank you. Next hearing set for 10:45. We'll take a short recess until that. We're on the record in People versus Alma. This is file number 236665. Mr. Alma is present in the courtroom today, as is Mr. Rolla. And Mr. Alma, it's my understanding that the motion's not necessary anymore. Is that correct?
Yes, sir.
Okay. Mr. Rolla, anything you wanted to state for the record?
Other than that, we did file a brief, but again, apparently the motion's being withdrawn as the fines cost amount is paid. Okay. Thank you, Judge.
Did you have any questions at all, Mr. Alma?
No, sir.
Okay.
My family helped me out, so.
Okay. Thank you for appearing today. Appreciate that. That's all. You're free to go. Thank you.
All right, thank you.
That concludes our morning.